Hi, everyone. Thanks for being here. Happy to have you on this call on this Thursday afternoon. I'm losing track of days because I don't go into the office anymore. Today we have Antonia Roybal-Mack, our attorney, and she is joined by bankruptcy attorney Erika Poindexter. And before that, I just thought I would review what we're doing. You know, kind of a hollow victory, but we fought all year last year over the plastic bag bans. And some were more egregious than others. Some went further than others. Some were just plastic bag bans. And if you don't know, we fought pretty hard in Albuquerque and got restaurants carved out of the whole plastic ban because it was a ban on basically all restaurant plastic. So it was going to be very hard to send out to-go orders and very expensive. So, we're not against paper bags. We're just, at that time, we kept telling them that single-use plastic bags are the most sanitary thing you can use for restaurants and others really, but for restaurants in particular. And now they believe us, and they've all gone back on their bag bans because it's not sanitary to put food in reusable bags. So there you go. We won in a very roundabout way. Families First Coronavirus Recovery DOL regulations. We told you guys we would put this up, and here, this is what we were talking from yesterday, just some of it. So we put this up. We got this through our national group, and it is an update that TripAdvisor is allowing you guys to go in and change your TripAdvisor stuff, and it lets you tell people that you're temporarily closed, or your hours for takeout and your menu for takeout, etc. So please do that. I want my members, the New Mexico Restaurant Association members, to be first to do some of this, so that you're taking advantage of everything that's out there. Of course, we have our daily calls. Tomorrow we have, and John's not going to be here, but his sidekick Fred Morgan will be here on an industry call. And basically what they're going to discuss is how to turn your restaurant into a pop-up shop or a small convenience store for your neighborhood. And so I hope you can join us on that. It is something that came out from the governor's office.
Did you email her or did you text Adrian? Okay, cool. Let's stay out.
So it's basically, if you can and you're staying open already for takeout, there might be some sundry items that you can add to your takeout. Think about it. If it's that upsell, and now we're upselling toilet paper instead of an appetizer. So think about it that way, and see if we can't make that work. Now, I am putting together our week for next week. Next week, I know we have Wednesday, we have Michelle Duvall, it's a little bit different, but I think we're all extremely stressed at this time, and we probably need some help in how to de-stress and just get ourselves back to even. So Michelle Duvall is a mindfulness expert. I've actually taken classes with her. She's absolutely wonderful. She's just going to teach us how to do some things that will help us with our daily stress and help us sleep and other things. So I think that's going to be very interesting on Wednesday. And you're welcome to invite other people to that call. Hopefully we'll have our Facebook Live up again, and we'll be able to get people on our Facebook Live feed for that call. I just think it's something. Send it out to your broader folks. Most of these calls are for us, Restaurant Association folks, but for that, send it out to your broader friends, family, etc. Those people are stressing right now because of the situation will really benefit from this. We're also going to try to send it out to as many of the employees in our industry as well, because we know they're stressing as well. So That is Wednesday. And then on Friday, we have Jonathan Gerhardt from the New Mexico Environment Department coming on, just telling us what they're up to and how they see this going, and maybe how they see us coming out of this a little bit too. Because I'd love to start discussing that, right? I'd love to see the light at the end of the tunnel. So I'm also looking at on Monday trying to get somebody from the workforce development office on the call. And then we're thinking maybe we'll do Monday, Wednesday, Friday next week and not Tuesday and Thursday. We'll just see how it goes and see if I get any interesting folks. If not, then we'll do Monday, Wednesday, Friday, and we'll keep you abreast of that. And
Carol, this is Allison.
Yeah,
Before you go on to the other, I just wanted to let the group know the governor is going to be having another press conference today at 4, and you can catch that live on her Facebook page.
well, hopefully she has a better try with Facebook than I did.
Yeah.
The other things are there's the 2 links that we talked about yesterday, so those are here for you guys to look at. And with that, I am happy to have back Antonia Roybal-Mack, our attorney for the New Mexico Restaurant Association, and she has brought a special guest, attorney Erika Poindexter. And Antonia, right now, I don't see Erika on, so oh yes, I do.
Yeah, she's on the participants list, so you might have to make her a you know this better than I do, but she is on there.
Okay, got it. And Erika, I'm making you a co-host right now, which you are unmuted as well.
So thank you, Carol. And I want to introduce Erika. You know, to put this into perspective, I had a client some time back, and, you know, bankruptcy was really the most feasible and logical answer for her. And she said, she put it into perspective for me because I knew how horrible that would be and how I would feel if bankruptcy was what I was looking at for my business. And she says, well, when I opened a business, the worst thing that could have happened to me was I go bankrupt. She said, they can't take away my birthday. And that kind of made me laugh because that's the truth, you know, and it's this piece of the law that as business owners, we don't want to talk about, we don't want to think about, but sometimes the protections of the bankruptcy court are the best protections available to a client, and they're the best protections available in a circumstance where somebody's just so overwhelmed. For those businesses that were having cash flow issues before this, you know, this might really be a viable answer. And the reason I'm bringing Erika on is I've had just this week a number of people who are having trouble with the leases and the landlords saying pay up or you're going to get locked out. And it's no restaurant people, which is good. But in that situation, many people are personally guaranteed on their company's lease. They have a personal guarantee on line of credit. And what that means is that if this business is not successful, you still owe the money. So sometimes, you know, these leases, the value of the overall lease over 5 years could be $500,000 plus. So Erika Poindexter is a very good bankruptcy attorney. I send many clients to her. This is not the area you want to talk to me about necessarily, because I'll just tell you to go call Erika. And without further ado, I'll turn it over to her to give you some background of how this process works and any specific questions your people might have, Carol.
Thanks so much. Thanks for being here.
Absolutely. Thank you, Antonia. I think I want to start by saying that when we start talking about bankruptcy, we need to differentiate between chapters in bankruptcy, because bankruptcy is, we use it as a catch-all, but the relief available varies based on individual circumstances. So in some situations, we're talking about what people think of as traditional bankruptcy, which is Chapter 7. That's liquidation. That is, we are shutting down, we are closing a business, and that is very different from Chapter 11 bankruptcy, where we are looking to reorganize a business and make it a viable business model. That something may have gone wrong, something may have failed. I mean, for some businesses, that could be one lost contract, and the debt that they have related to their business is suddenly spiraling. So in a situation where we're doing a Chapter 11 reorganization, we're not looking to close that business down. We are looking to make that business viable, but reorganize that business's debt in a way that those creditors get paid back a reasonable sum, and that that business remains open and employing other folks around the city and around the state. So it can be very different. Sometimes we are looking at liquidation. Folks just need to walk away, and that is always a viable option when it's just gotten to be too much. But oftentimes it isn't that. It is, okay, we can make this work, but we need some time. We cannot pay back on the schedule that was originally agreed. We're going to need some extra time, and we're going to need some safeguards that force those creditors to work with us. And that is best found in bankruptcy court. And in fact, we had a pretty significant law change just recently in February related to small businesses in particular. Back in 2005, we had a law change. It was the most significant change in the bankruptcy laws since the 1970s. We call it BAP-CAPA, some call it BAP-CPA, but it was the Bankruptcy Abuse and Prevention Act of 2005. And one of the sections that was changed was regarding Chapter 11 reorganization in small businesses. So prior to 2005, there was no special designation for a small business. It was a large catch-all. You could be the mom and pop shop, or you could be Circuit City, and you were being treated exactly the same. And of course, that was ridiculous. There are very different considerations for both of those. And so we have this designation as a small business all of a sudden popping up in 2005. And what I found working through that is that I wasn't actually using that designation, even for small businesses, because in many ways, it was actually harder to get through a case under that designation than it was under just the original Chapter 11 reorganization section, just saying it was a business. And so I think a lot of attorneys found themselves in the same situation. This definitely was something that needed to go back and be reviewed because it was having the exact opposite effect of what was intended. And so in February, we have the Small Business Relief Act passed. We have a change and a shift in what it means to file for Chapter 11 as a small business. And now it's looking much more like we expected it to back in 2005, which is essentially back in 2005, we were hoping that what we were going to get was something very similar to Chapter 13 for individuals, only geared towards small businesses. And now that is what it is looking like. We have a much different designation. The sections and the applicable law have changed dramatically. And where that is going to be most important is fees. So one of the problems with how it was originally changed is there really wasn't a reduction in fees. The cost of doing a small business bankruptcy was not any different than a regular bankruptcy. In fact, in some ways it was tougher. And so some attorneys were charging more to do that small business designation. Now they've pulled back. They've made it easier and less complex, which I think was the original intention in the first place, and less costly. One of the biggest hurdles for small businesses was having to pay quarterly fees to the trustee every 4 months, and those could be tens of thousands of dollars in certain situations because it was based on the money coming into the business, and those fees have been eliminated.
As a question here, what is the definition of small business in this small business capability?
So we were looking at small business as businesses with gross annual revenues under $10 million.
Okay. All right.
So that is a lot of businesses. That is
Yeah.
a lot of businesses. But they weren't using the designation because there was no benefit. When you are looking at, okay, if I bring in, you know, at a minimum, even if with the minimum, they were paying $725 a quarter to the trustee's office, even if their gross revenue for that quarter was $10,000.
Yeah.
It's a huge sum of money for a very small, you know, for a business that is not having those kinds of gains. And so eliminating those fees was a big deal, streamlining the process. There would also be, and this is a very big change, is we would not have a creditors committee in a small business case at this point in time. And it doesn't sound like a big deal, but trying to wrangle a bunch of creditors to be on a committee and agree to something was not was not good. And it was very hard to do. And again, it would just run the fees up in a case. Because you had creditors who didn't want to participate. You're trying to get them pulled together to agree to a plan. And so they've eliminated that and instead done what we were doing, have always done in 13s, which is having a trustee help administer the case. And so now we have that for small businesses as well. And that can be somewhat daunting, hearing that a trustee will be involved in the case, but their large role in the case is making sure that the creditors get paid and that the business remains viable. And it has worked out very well for individual creditors, and I think it was time for there to be that option for small businesses as well.
Nice. So can you tell us a little bit, I mean, one of the things we said that we were going to do here is and Antonia said, what is the process if someone needs to evaluate? Is it time for me to think about bankruptcy, and how do I protect my personal assets? I just want to say I heard just a horrible statistic, and it came from a group that I'm with, the Western States Restaurant Associations, and they were talking about between 25 and 60% of small independent restaurants being gone at the end of this. And, you know, I can't even imagine that. But I certainly want them to be protected if that is what happens, right? I think the 60% is high. I think we'll make it through a little bit better in New Mexico. We always seem to. We have the federal government and lots of things that keep us above water in situations like this. But anyway, if you could just talk to that a little bit.
Well, and I think when we're talking about those personal guarantees, and it's an excellent point to bring up, because oftentimes I think, and I am as guilty as anyone about not always reading the fine print and not seeing or recognizing what that personal guarantee may mean down the road. And so when you're looking at personal guarantees, the big problem is you've started a business, your business may be very successful, there's a downturn for whatever reason, and then you're trying to reorganize, and let's say you go to a bankruptcy attorney, and one of the first questions they're going to have is, okay, is that debt personally guaranteed? And oftentimes the answer I get is, well, what do you mean? And so that I totally feel that pain, because it's, you know, people I think really make that assumption. I went in there as a business to get a loan. I got that loan. I didn't read the fine print, and no one pointed out that in fact I was using myself and my assets to guarantee this loan. And now that it's come due and I'm unable to pay it, what does that mean for me? I often want to tell people, almost when we're talking about smaller businesses, there are going to be a lot of personal guarantees, whether you realize they're there or not. If you go back and look, we kind of find them in that fine print all the time. And what that essentially means is if you file for bankruptcy as a business, all that's being taken care of is that debt as a business. So that debt, that business may no longer be liable, but you still are. And so then we have to shift and look at what do we need to do. So if a business, let's say, is closing down, one, we have to look at things like, of course, things like leases and rental agreements. And oftentimes those have personal guarantees in them. We have to look at inventory of the business, if there's inventory related to that business, because what we may be doing is an individual rather than a business bankruptcy at that point. Because once a business is defunct, it's no longer active, you know, people can sue them all day, sue the business all day. They're not going to get anything.
Right.
There's nothing there to get. But that individual is still there. They backed those loans, and that's who they're going to come after. And so having done that business bankruptcy, it may not be providing the relief that someone was looking for, because there's still those personal guarantees out there, and those creditors are going to come looking for that money from those individuals. And so sometimes we're looking.
Those personal guarantees go everywhere. I mean, suppliers actually won't even supply to you unless you've given a personal guarantee. And honestly, I don't think you remember that. You know, I mean, you're just setting up an account with them, and you don't realize that you've just guaranteed everything you buy from them personally. And they can go back on your house, they can go back on your assets. So let's just say I'm a business that, you know, I can't make it through this. I don't have enough cash. I'm bleeding cash, and I don't have any income coming in. So what do? Do I then make the decision to claim bankruptcy for both entities, the personal and the business, or do I see where most of the guarantee is and go with one of those? I don't even know if that's a question that's, you know.
No, it's actually makes a lot of sense. And a lot of times what we're looking at is what kind of business are we looking at? Is there a need for both a business and an individual bankruptcy, or is it one or the other? Or sometimes it's both. Oftentimes it's going to depend on things like, is this a business that has inventory, and who owns the inventory? Because in that situation, we may have a business owning the inventory and not the individuals. And now we have a lease agreement where they want to hold on to the inventory, but maybe the inventory is a secured debt, and we've got to work through that process on the business end, but we also still have those personal guarantees. Sometimes the business is the person. They own everything. Their name is on everything. And so there's no need for us to even involve ourselves in a business bankruptcy, because everything is owned and backed by the individual. And really it's the individual bankruptcy that is going to wrap everything up and make sure that, to the extent creditors can be, they're taken care of, but that debt doesn't remain with them. Another very important thing about small business bankruptcies is we look at the difference, especially when someone as an individual needs to file. We look at whether or not most of their debt is consumer related or non-consumer related. So I've had cases in which an individual is filing for bankruptcy, and $250,000 of their debt is business related. It's non-consumer. It's not their house. It's not credit cards, personal credit cards. It is the business. Well, that provides a benefit when they're filing for bankruptcy, because in how bankruptcy is structured is you have to qualify for something like a Chapter 7 bankruptcy. In other words, you have to meet an income requirement related to that bankruptcy. And that income requirement is very low in New Mexico. It is based on our median income in the state for two people, a household of two right now. It's $54,000. I mean, it is very low. And so for some folks, they transition out of their business, but they have a very particular skill set and go from owning a business to being a high income employee somewhere else. And in that situation, it's like, well, what do? I have all this business debt. It's crushing me, but I'm making $80,000 a year, and I'm well over the median income in the state. Well, what we're going to do is we're going to look and we're going to analyze that debt. If I look at it and I see, well, this is all non-consumer debt. This is, you have $25,000 of actual consumer debt related to you and your household. The rest of this is business. We don't even have to worry about you meeting those income requirements, because if 50% or more is non-consumer debt, we don't even hit that particular test. We don't have to worry about it. So it's something to keep in mind that, most of the debt is related to the business. And I do include credit cards that are in the individual's names, because oftentimes we see that, it is, John Smith's credit card. It doesn't have the business's name on it, but if you actually look at their monthly statements, it's clear all of that debt is business, right, and business related. And so it is not just, but I do have these credit cards, but they're all in my name. No, that's not what the bankruptcy law says. It says we got to look at that debt and see whether or not it is consumer or non-consumer debt. And if it's non-consumer debt, and 50% of your overall debt is non-consumer debt, then we don't have to worry about an income requirement in that situation.
What about personal guarantees in that situation?
Personal guarantees in that situation, I want to differentiate between, so the personal guarantee, it's largely going to be how that is written. Because some personal guarantees are written more like liens than they are just straight personal guarantees. Right. Not just the debt traveling to the individual, but it actually being secured by collateral. Right. If it's secured by collateral, we've kind of got an extra step in there. Maybe we're looking at a 13, or we're looking at an individual 11 to make sure that we can reorganize and take care of that. If it's a straight personal guarantee, that is either, secured, or maybe secured by inventory, someone's willing to give back, and then all that's left is the straight personal guarantee, then that's just going to be treated as any other unsecured debt in an individual bankruptcy case.
So let's say, I'm sitting out here and I realize I don't have enough cash. I mean, I'm bleeding cash. I don't have enough cash to stay open with my restaurant right now. And how do I evaluate if now is the time to do this?
It's always it's such a personal decision. I always say, one, you want to go and talk to your tax professional, because there are some decisions that get made that we really can't draw back on. And particularly now, we've had some significant changes with the new stimulus bill that may change how people approach trying to keep businesses afloat. There are some things that I would never in a million years suggest people do that all of a sudden look a lot more palatable under the new stimulus bill. So let's say someone is sitting on money in their IRA or 401k, and they feel like they can ride it out for a few more months, but they need an influx of cash now. Well, the rules have changed regarding those withdrawals on 401ks and IRAs. And so I think it's really important people go and talk to a tax professional first and find out, is there money they can tap into if they really have a legitimate reason to believe they can ride it out. Other times, if that's just, there's nothing there, there's no economic relief available, the loan programs are just not going to work out, things are really bad, it's probably time to talk to a bankruptcy attorney at that point. Maybe you're not going to file in that moment or even within the next month, but at that point you need some guidance about what you need to prepare for if it comes to the edge. Like, you want to know, what am I getting into and what my options are going to be? because maybe after speaking to a bankruptcy attorney, you're like, well, maybe Chapter 11 is the answer here.
Mhm.
It's not that I'm bleeding money, but if I can just restructure the debt, I have confidence that the money will start coming back in. There's a good reason to believe it'll start coming back in and we'll start making a profit. Other times it's just well past that point, and it's about, well, how do we fold everything up, make sure that we don't have existing liabilities coming out of this situation.
Great answers. Now, have been taking notes, and you mentioned a Chapter 7, which is shutting down, a Chapter 11, which is reorganizing. You mentioned the Chapter 13, but I didn't get what that was.
So the Chapter 13 is reorganization as well. It's just reorganization for an individual rather than for business. So that's where I was. I'm sorry. I should have filled in that blank.
No, that's okay. It may have been me.
Oftentimes we have people who don't meet the income requirements of 7, or they have a debt that can be reorganized and needs to be reorganized so that they can continue to make payments on it without the stress of, having like their home foreclosed on them or their vehicle repossessed. Because it's oftentimes when we're looking at 13s, that's the reason why we're filing a 13. Someone may be 4 months behind on their mortgage. The chances of them being able to catch up on that all at the same time is pretty slim, absent a lottery win,
Right.
or some other windfall. And so we're going to have to find a way to reorganize that debt in a way that those back payments, or as we call them in bankruptcy court, arrearages, get paid back over the life of the Chapter 13 plan. And that's what we're seeking to do and asking the court to approve. So it is something to think about, in fact, because I have been seeing some forbearance agreements floating around. People are posting them where their mortgage companies is seemingly being very nice by, giving them forbearance for 2 or 3 months. But the fact is, if they're really looking, what they're seeing is that all of the payments are going to be due. They haven't pushed them to the back of the loan. They are just putting them off for that period of time. And then all of a sudden someone's going to owe $8,000, $9,000 in mortgage arrears and current payment on that 3rd or 4th month. And so
and in restaurants, we're just barely going to be getting back up again. Right. So I want to caution people too, we're not going to go from where we were in February immediately when this is over. We're going to get a ramp up. I think people are going to be able to get out of their houses, but some of them are going to be afraid to do that. We're still going to be at 20%, 40% occupancy. So I just want to caution people about that. I've got a couple of questions. Do you want me to go with those, or do you have more?
Absolutely.
So one of the questions is, how about an LLC? Does this entity protect your personal assets?
Yes and no. The fact is, an LLC, it's really its intention is to protect you to some extent. But oftentimes what we're looking at in terms of protection in those LLCs is protecting you against liability and being personally sued for something like a slip and fall in your business. When you personally guarantee a debt, you personally guaranteed no matter how your business is organized.
Not many creditors will allow you to sign as your LLC. They are asking, and that's why it's called a personal guarantee, is because you are personally guaranteeing this and usually putting collateral like your home against it. And I can remember
Exactly.
my SBA loan when I was in the business. It was a personal guarantee against my house. I know that I had personal guarantees with my suppliers, my lease, my loans. Everything was personally guaranteed. So even though I had an LLC, it didn't really matter because, again, you're right, that protects you from the slip and falls, that protects you from the liability, but it does not protect you if you have given personal guarantees. So.
And so that can be really, really tough to navigate. And I mean, and I think that is part of the problem is its intention is one thing, but the reality is going to be very, very different. I'm an LLC. I'm a single member LLC. Any debts related to my business, those are my debts. They're just mine. The
well,
LLC
and you know that creditors, well, and your business is a little bit more stable than ours, but restaurants are known to go in and out, and so creditors are very hesitant to do anything that is not personally guaranteed.
Exactly. I mean, it is, unless we are talking about a corporation bringing in several $1 million a year, I think on up. I mean, even then, sometimes we're still seeing personal guarantees. So it is, it is very hard. It's about being incredibly savvy, I think, especially right now, about taking loans and what that entails. The payment protection program, or the payroll protection program, sounds great on its face, and it's going to be good for a lot of businesses. You essentially are taking out this payroll loan, 2.5 times whatever your payroll is. Great. It can keep you afloat for a while. And there's a forgiveness provision that I think a lot of people are counting on. But the fact is that provision is there to make sure that you rehire people and keep them in positions later on. And if you fail to do so, then that money's going to come due. So it's all of those little clauses in there that you have to be really careful about. And so, I'm always going to suggest that if you have a business law attorney that you have a relationship with, that you speak with them before taking out a loan. And frankly, I'm just one of those people who, if I am going in and talking to a loan officer, I will make them explain something to me in excruciating detail. Yeah. I'm like, let's assume that I didn't go past the 3rd grade. I want you to explain it to me like that.
Yeah.
Because, it is really, for a time, particularly in the 2000s, credit was very readily available. There were people lending, and brokers and lenders, and just, they didn't want to explain anything. They just would sell you on how easy it was to get the credit.
Right.
And it put a lot of people in jeopardy when 2008 rolled around and we had this huge crash. And so we just don't want to repeat those mistakes of the past and know what we're getting into, even with these loans becoming so readily available right now.
Yeah, well, exactly. At some point, those, you have to pay those back, and especially in the restaurant industry, it's not easy. You don't have a whole lot of money at the end of the month anyway, and then to have an additional loan, just be sure that that's something that, and ask the questions, how much is this going to be on a monthly basis? A lot of us are out there applying for these idle loans, and we don't know what it's going to cost us on a monthly basis, because that's not actually something that's in the loan application. So keep that in mind. I have some more questions here. Do both Chapter 7 and Chapter 11 affect you negatively in the same way in the future?
No, and I would say that because obviously a Chapter 7 is a liquidation, and so there are different. If you're liquidating, you are discharging debt in its entirety. A Chapter 11 is reorganization of debt. So creditors certainly are going to look at the fact that there was an attempt to pay back that debt versus not. And that's not to say that Chapter 7 isn't a viable option. Oftentimes, I'm telling people, honestly, it can't, at some points it can't get any worse. Chapter 7 can only turn things around at certain points in time. And so, but the 11 is an effort to reorganize and repay. So it is looked at differently than a Chapter 7.
So we're all used to seeing that. Have you filed bankruptcy in, 7 years or something? So how does it affect your personal credit, yeah. So can you talk about that?
So one thing that's very interesting is when it comes to credit scores, how TransUnion, Equifax, Experian actually calculate those FICO scores is a trade secret. It is not information that is readily available. We have models that kind of make a best guess at it, but we don't have an exact formula for how they're calculating that schedule or that score, and they don't have to tell us. They are kind of private businesses.
It's like the Facebook algorithm or the Google algorithm.
Exactly.
Yeah. It's trade
secret.
So
we have an idea, but we don't have an actual knowledge of how that number is calculated. So what we typically see, and kind of, again, this is kind of the best of our knowledge, is what we see in terms of a person's credit score after Chapter 7 filing is an immediate drop in score, and that could be over 100 points. However, then as people are moving, usually a year past that bankruptcy, depending on what has gone on during that time, you could see someone whose score 1 has completely recovered, and oftentimes people whose score is higher than before they filed because they don't have all of that existing debt on their credit report. I think the next question I typically get is, okay, so that happens. When am I going to be able to get credit again? Unfortunately, almost right away. And when I say unfortunately, it's because like many other, like a lot of lenders, there are predatory lenders who actually are looking for people who have recently filed for bankruptcy. They are stalking the bankruptcy court, and they are there ready and willing to lend to people who have just come out of a distressed situation. But obviously those types of loans, that type of credit is going to come with some very high risks. So
yeah, you hear about that all the time. If people who claim bankruptcy, and then all of a sudden the credit card companies are all sending them, here, take mine.
Car companies, yeah, but we're seeing these credit cards at sometimes 35, 40%. Yeah, so it's dramatic. If we're talking about when reasonable credit comes back around, we're looking a year past that bankruptcy, assuming that there haven't been any stumbles along the way. I definitely wouldn't make a guarantee about that, but certainly if people have used credit responsibly from the period that they filed to a year later, they're looking at much, much different rates than they were right after filing. Usually what they would normally be looking at, I think a lot of people are like, well, what about a home? What if I need to buy a home a year down the line? It's like, well, a year down the line, it's going to be a tough sell. 18 months is actually what we're looking at right now. I mean, I don't want to say right now because of course we're going through all this, but prior, 18 months was where we were at, which was down from 3 years, which was, probably 2015 or so. So that gap time to when lenders are really looking at you had really shrunk prior to COVID-19.
Right. So I've got a question, and you seem to know something about this, so I'll put you on the on the line here. Are the current EIDL loans requiring personal guarantees for the current loan application? And are you saying that after the 8 weeks of PPP loan, you can no longer lay off the employee?
So with the EIDL loans, and I'm honestly, I'm getting as caught up as everyone else. I believe I did see some information in there about personal guarantees, but these are also much lower interest loans than we were seeing before. So there's some give there, but yes, with those SBA loans still being personally guaranteed. And
Antonia, you might be able to take this. I heard that there's a limit. So if you stay under like a $200,000 limit on the loan, you don't have to have a personal guarantee, but I don't know if that's correct or not. Antonia might know. Antonia, you want me to unmute you? You know, or I am going to unmute you. You can't tell me.
Unmute myself. Okay, I'm sorry. I was having some technical difficulty there. On the EIDL loan, if it's $200,000 or less, you don't need a personal guarantee the way it's written. $200,000 or more, you do need a personal guarantee. The PPP has no personal guarantee.
Okay, thank you. See, I was kind of right. And then, so second question, are you saying that after the 8 weeks of PPP, you can no longer lay off that employee? I've not heard that, Patrick.
Well, there are some provisions in there that people really need to look at about what happens 6 months down the line after the assumption is that there's a recovery. When I was looking at that, I was looking for me personally. So
Right.
I was picking through for the provisions related to my business. So I certainly am not going to be the one who is the expert on the loans, because my experience is really related to what I needed to look at personally for my business. And now we're just starting to get caught up on what that's going to look like in terms of what that will be for bankruptcy, what stimulus money, how that will affect bankruptcies, et cetera. We're also looking at the fact that we already have another bill coming down the line. And so this is incredibly dynamic, and information you have today may look totally different even 2 weeks from now. And we are actually anticipating a third and even possibly a fourth bill. So we're going to be moving a lot from where we are today, and have had movement even from where we were 2 weeks ago. And so more money is going to become available. Hopefully some of the bankruptcy provisions will begin to loosen up. Some of them already have. When we just 2 weeks ago, the longest you could run on a Chapter 13 or Chapter 11 plan was 5 years, and now it's 7. So that's a huge shift, one we have not seen in the past.
Did that come with the CARES Act? Or
it did.
Interesting. So they're already planning on this.
They are already planning on it, but there's also a big provision in here that there's a sunset clause. So essentially, we're looking at these provisions for a year, and then it's going to go back to the normal provisions. So there is going to be, kind of a year timeline where we can take advantage of this, and then that is going to go away. So, I mean, it's a big deal looking at things like unemployment and stimulus money not being counted as income. It's a really interesting model so far, but they're going to have to do more for small businesses if we're going to have sufficient recovery. So I expect some of that to change in a positive way as we keep moving forward.
And I was looking forward in this questions. If a business has an employee, is it true that it does not have to pay federal and state withholdings, SUTA, or other deductions from the employee's paycheck? And I'm sorry, we were in the middle of the payroll protection and the EIDL loans and all of that in previous phone calls. So I think some of these are coming back up from that. I don't think this has to do with Duke. Can you clarify, does this have to do with Bankruptcy, I don't believe so. I think this has to do with the EIDL, not the EIDL, the PPP loan. And I just got something from one of my members. Let me see if I can. So I'm going to show this to you. At the end of the Q&A, it seems to interpret payroll costs as including employers' FICA and withholding taxes. The worksheet I use to calculate the payroll costs exclude the employees. So this is the gentleman that put together the worksheet for us. He said that's changed. The last line of the Q&A, and what did he do? Let me get this. Anyway, I have an answer for that, Duke. If you will email me at executive@nmrestaurants.org, and I will answer that question offline with you. If anybody else wants the same answer, just email me. I know that it changed a bit with their new Q&A, and like you say, Erika, things are changing. I mean, just, you know, on a daily basis, we get new regs that are interpreting what we heard. What was it, Antonia, last week, like last Friday, you were reviewing the CARES Act, and it's Thursday now, and it's changed a couple of times since then. And you know, I just want to say it hasn't necessarily changed, but as with any law, it comes with a set of regulations, and we had not at that point had a chance to look at the regulations. My big push has been getting my members some of this relief while it's still out there. And so I'm kind of telling them, get the relief, we'll figure it out. If it's wrong for you, you don't have to take it.
And I think that's honestly, and that is I think general consensus around bankruptcy from bankruptcy attorneys is go ahead and apply.
Right.
Just apply. You don't have to take a loan that is offered. You don't have to take relief that is offered. But if you do not apply now, these are programs with limited funds, and once they are exhausted, they're exhausted. And so we have this new bill walking through that's, you know, supposed to be another $250 billion, which of course sounds like a huge sum of money, but it's really not. And you know, I'm sure many of you have already experienced that some banks are like, we've already exhausted the funds related to these programs. We can't help you. So it's a matter of apply and decide later rather than decide whether you want to apply.
Yes. Yeah. I mean, tomorrow's almost too late because a lot of banks have stopped with those loan programs. And from what I heard, Congress didn't get anywhere with the extension. As of today, they're still talking about it, I think, but they refused to extend any more money into those loan programs right now. Other questions, folks? And you can unmute yourself if you want. If you want to chat, you're welcome to. You know, I'm trying to fix my budget and figure out. Yeah, we won't go bankrupt as far as the association goes, but certainly it's going to be tight. And, you know, I mean, I've got to look at the fact that my members can't right now. They can't pay their membership dues necessarily. And I certainly am not going to ask for that. So we've got to figure out other ways to bring money in. So yeah, I think everybody's just trying to figure out how long they have, you know, what is my runway here, and am I going to make it to the end, or am I going to have enough to get to the reopening? And so I think a lot of folks would love to have a date certain. And I know that's kind of what we're looking for. What is the date certain? As a matter of fact, I will just let everybody know that the governor is going to be on Facebook Live here at 4 o'clock, so we won't keep going for any much longer. Do you have any parting thoughts, Erika?
I do, just in that if you would like me to send you some of the information that I received today related to the Small Business Act, I'm happy to do that. The Small Business Act and CARES, I should say.
Right.
I'm happy to do that, knowing, of course, that this is dynamic and that we can have some changes along the way. We're going to have to. I mean, a bill failing today, you know, they're putting them together on the fly. They're trying to do the best that they can, but you know, it is definitely a situation that's moving very, very quickly. And a lot of this is us, you know, trying to figure out how to get the best information out to our clients as quickly as possible, making sure they have the information they need. And so if I can help in terms of getting out information regarding other issues, whether it is draws on retirement, student loans, how the mortgages are being handled, I'm happy to do that, put together a brochure or something that explains that a little further.
I appreciate that. And maybe even just a 5-step, what would make you think you need to file bankruptcy, right? I mean, there's these 5 things. Creditors are knocking at your door, I mean, I don't know if it goes that far, but certainly, if you aren't going to be able to make it to the end of this and then reopen again, maybe bankruptcy is a better choice for you than just walking away from it all, right?
Yes, I mean, certainly anytime you have a personal guarantee, and I think a lot of times people, I wouldn't say necessarily business people, but certainly as individuals, they spend a lot of time running from the debt because they're scared to confront it.
Yes.
And the fact is that bankruptcy is not about people losing control. It's about taking it back. Just like there are provisions for you as the debtor, there are provisions for the creditor as well. And so they have to play fair in bankruptcy court. And they are locked in to certain provisions that are not in state court. There are things that they're just not going to be able to do. They're not going to be able to keep calling you and chasing you down if you file for bankruptcy protection. And we call it bankruptcy protection for a reason, because it's really there to protect the debtor, not necessarily to benefit the creditor.
Well, wonderful. Thank you for coming on. And Antonia, thank you for giving us this wonderful associate. Really appreciate it, Erika and Antonia. Tomorrow we will have Cisco on, and they are going to be talking about restaurants as pop-up shops, how to make your restaurant a place for convenience, sandries, etc. Antonia, I'm sorry, I broke into you.
Oh, no, I just wanted to thank Erika. We'll make sure, Erika, that they have your contact information, and if any information you send, Carol will get to her members. But she is most certainly well respected and trusted if anybody feels like they need to have a private consultation with her.
Erika, what firm do you work with?
My firm is called Poindexter Law.
Okay.
My email address, if anyone wants to email me directly, is fairly easy to remember because it's my name. It's Erika, and that's with a K, at erikapoindexter.com.
Great. And Antonia is with Roybal-Mack and Cordova Law. Is that right, Antonia? Did I get that?
Correct.
Okay.
Yes, that's it.
Okay. And we'll put their contact information on tomorrow's alert, so you can look for that. I thank you all for being here. I hope what you're hearing is helpful. If there's somebody you want us to have on these calls, please let me know. Like I say, next week we've got a mindfulness expert on Wednesday, and on Friday we have Jonathan Gearhart from the Environment Department. I'm looking to have somebody from the Workforce Development Department on Monday, and then we're thinking about not doing this on Tuesday and Thursday, so let me know. Just send me a quick email and tell me, if you want one of these every day, we'll get on with you and we'll answer your questions. And it's also, it's good to see you all out there. So Again, it's executive@nmrestaurants.org if you want to contact me, and you're always welcome to. So thank you all for being here. Thank you, Erika, and thank you, Antonia.
Thank you for having
Thanks
me.
for having us.
Bye-bye.
Have a good day. Thanks, Erica.
You too.